All right, just give us a moment, Mr. Selenus. Could I have the paperwork on Selenus, please?
And Judge, good morning.
All right, Lauren, could you fix the sound? Thank you.
Judge, can you hear me?
I'm logging in right now, Judge. I didn't have anything printed out. How much is that? No, it's back there. I didn't see the difference.
Greg, what's happening with your case?
Judge, where the paperwork is all done, we just need to sign it. He just needs to sign it, unless he did it so I can go over him. I did it last night. But I still need to go over with him.
All right, so there should be paperwork in your box.
In my inbox or my,
Yes.
okay, I'll look right now.
All right, and what I'm going to do is I'm going to create some breakout rooms. And I will send you all to breakout room number 1. And they'll be sending the paperwork to you all. He's like, he's. Hello, hi. Oh, let me know when you all are ready. Oh, no, come in. We just have some cases called back on the docket, but. Hello, ma'am. Just one moment. You're welcome.
So just do this paperwork is it's put it either here, Gaia, and then we'll swear in.
All right, so he's assuming, I need one of you all to go to breakout room number 1 to see if he even has paperwork.
The flow of paperwork for Adobe saying Judge went from defense counsel, now it's pending the Bear County Jail iPad
Okay,
for signature, and then it will go to the clerks for.
Thank you.
all right, thank you.
I was like, where are you?
Oh, that was the thing. Lauren, when it gets to that stage, can you please go to Yaya? She's gonna log in back there and sign in back there. Okay, thank you so much. Huh?
All right, probation. Yeah, so we have a lot going on. And then my mom's I'm trying to help her with some technical issues on her end. So yeah. So it's a lot that's going on today. But hey, it's exciting. It's Friday.
And you leave.
Yes.
Good.
Yeah, enjoying mom, enjoying family.
Love it.
So
Judge, my grandma, she's like late 70s, she's drawn to fashion. And so she says every day, I love Joy's purse today. I love her purse today. And yesterday she's like, I know she had that one there for me.
Yeah.
It's her favorite color yellow.
oh, tell her I said hi. Yeah.
She religiously watched her.
Oh. And then last night I had class. So I was able to rush, pick up something from Salada. And it's never good not to have breakfast or lunch. And so I was like, but when people say, oh my gosh, I'm starving. I wasn't starving, I could survive, but it's just not a good thing to do. So when I left here, I was like, oh, please let me make it to Salada before my class starts. And so there's all this traffic on 410, but I made it
Oh, good.
because there are Saladas, like the one that is on 410 near the mall and the one at Hebner. Great. I've never had any issues with it.
40.
Yeah.
Oh.
Everybody I know, that's where that's happened. So I always go to the one on 410 or the one on Hebner.
Okay.
And I always get the same thing. And then they will ask me, I have the crab meat. And then they will ask me, cookie, nuts. And now that they know, but they're like, Stephanie's a country girl. No, she doesn't want all that extra stuff. And they're like, you want bread? I'm like, I told you guys I'm dieting. You want a drink? I'm like, no. I only get their drink when I'm cheating, for my cheat day. Because their lemonade drinks are great. So
It's not a dressing they just have, but it's something that one of the employees one time told me about, that people mix the lemon and the balsamic vinegar together. It's so good.
okay, I'm gonna have to try that because I do the balsamic vinaigrette. But I told them I really would love if they had the purple cabbage and not the, everything. It's like, do just purple cabbage. So they said, oh, we'll make that for you. Like, because I love the purple cabbage. So
Like I said, 'cause I've never tried the crab.
so what I do is I do the salada mix, the mixed cabbage, extra carrots for my eyes, for my peepers, extra cucumbers, extra tomatoes, just a sprinkle of mushrooms.
Yes.
If I'm feeling like wild and exotic, I'll do a little bit of the mixed cheese. Then I do the balsamic vinaigrette, and then I do the crab meat, and that's it.
Sounds good.
Yeah.
I like to do the broccoli, I like to do artichokes.
See, I think that
I'm exotic.
I will tell you, some of it looks good. Like I'll be in line and people will throw in lima beans and all this other stuff. I'm like, that looks great. And then they'll do the pasta. I'm like, the colors look beautiful. I just don't know how to. And then somebody throwing beets in. I'm just like, okay. Yeah. One time I got very crazy and I did what did I do? I had them put egg in it. Oh no, I had to say no. Hey Charles, how's it going?
It's going very good. How are you?
Oh, I'm doing great. I'm loving your shirt.
Is that
Thank
sea
you.
lion?
No, those are birds.
Oh, okay.
All right, who do you have, Charles?
Caitlyn Medell.
Caitlyn Medell.
The paperwork's already turned in.
All right, is she on bond?
No, she's in jail.
All right, they went to go get the inmates, so they'll be bringing them out.
Okay, I'm standing.
All right, as soon as they bring them out, I will take you out. Do you have
All
a
right, thank you.
I do, I'm gonna sign it, but I still need to swear her in.
Hello, hello. Oh, that's never good.
It's been a morning.
Hello, Ma'am Ruth. Thank you so much for staying connected.
All righty, Greg, just waiting on your paperwork.
Yes, ma'am. And thank you, Judge, for allowing us to do this.
All right, Mr. Let me see, Luis Selenus,
Yes, ma'am.
We're ready, Judge.
who's attorney for Medell? Okay, and is his client here? All right, so we'll go with Mr. Selenus first. Cindy, are you ready?
Yes.
Court is calling 2026 CR 000273. State versus Plea, Selenus. Can I have parties announced for the record?
David Woodard, he's on, just talk to him. He's already there.
Greg Desmarais for Mr. Salinas.
Don't
And
touch
are you
anything.
Mr. Salinas?
Hello.
Yes, ma'am.
Oh, yes, I did.
All right. And this is an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
The court will find that the state is in compliance with discovery. Mr.
32.
Salinas, did you review the consent to plea by video conference with your attorney? Did you understand it and sign it and electronically sign it?
Yes, Judge.
We did, Judge.
All right, court will find that defendant has no
Five,
voluntarily consented to appear by video conference. Mr. Salinas, did you review the application for community supervision and electronically sign it?
Yeah.
Yes, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we waive count 1 and proceed on count 2.
Any objection?
No objections, Your Honor.
Mr. Salinas, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
All right, you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. If the state proves up the enhancement allegation, your range of punishment will be anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do.
Mr. Salinas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's an $800 fine. State recommends community supervision, and they're proceeding on count 2. And you're to agree that you've been previously convicted of 2 or more felonies for purposes of enhancement. Did you understand that to be your plea?
You said prison, ma'am, or probation?
I said that the plea bargaining agreement is 2 years in prison. There's an
Oh, okay.
$800 fine. The state recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a top evaluation, 120 hours of community service restitution, the DOEP course, regular random UAs, and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest.
To enhancements, how do you plead? True or not true?
True.
True.
State, any evidence?
Yes, Judge. State offers states exhibit 1 in all documents.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, waiving the PSI.
Anything you wish to say on behalf of your client?
Your Honor, as you can tell by the deal, I think this is a good opportunity for the client, for Mr. Selenus to do what he's supposed to do. He's motivated, and I would just ask you to follow the plea bargain.
All right, Mr. Selenus, do you have any children?
No, ma'am.
All right, who do you live by yourself or with someone else?
I would say my mom's.
All right, so how often have you been using?
I would say just occasionally.
Okay, so here's the thing. You need to be honest with me because in the report, it says that you were found passed out. And I can tell you all drugs are dangerous, but fentanyl is especially dangerous. So I need you to be honest with me so that I can get you the help that you need. I'm going to follow your agreement. I'm going to grant your application for probation, but I need to try to figure out what programs are best for you because otherwise only 1 or 2 things going to end up happening. Either you're going to end up in somebody's jail or prison for the rest of your life, or somebody may end up having to identify your body. And from reading this police report, you were close to that happening. So how often have you been using and what have you been using?
I mean, I just use it occasionally, ma'am.
What does that mean? Occasionally.
Just maybe like once a week, twice a week.
Okay. So I'm going to give you conditions, and these conditions are to help you, okay? All right. So how far did you go in school?
I think 10th grade.
All right. This is what why did you drop out?
I started working.
Okay. This is what the court is going to do. The court is going to sentence you to 2 years in the prison, suspended and probated for 3 years. There's going to be regular reporting by Zoom or in person, regular random UAs in custody. I'm going to want an evaluation for felony drug court. Felony drug court will be able to see you first thing Monday because I'm going to sign that evaluation for today. I need you to be honest with them. They'll accept you in the program. They're going to help you with housing. They're going to help you with employment. They're going to help you, with your education. They'll be able to do all of that because you're going to need some extra help. If he's not accepted into felony drug court, I'm going to want a TAP evaluation, follow recommendations. Now, if you're accepted into felony drug court, which if you're honest with them, you will be, they will be in charge of your conditions of probation. There's going to be field visits 1 time per month until further notice. Proof of employment within 45 days of release, no employment as a home health care provider or minors. Are there any children that reside in the household with your mom?
No, ma'am.
All right. There's to be no residing in households with minors. There's to be no unsupervised contact with minors. There's going to be 300 hours of community service restitution. 100 of those hours will be deducted upon completion of a GED or some sort of trade school certification. The remaining hours, 1 hour will be deducted for every sober support meeting that is completed. There's an $800 fine. And that is going to be probated. So if you successfully complete probation, you won't have to pay that.
Okay.
Probation, is there anything else? Is there anything else you need from the court, Mr. Selenus, to be successful?
No, ma'am.
All right. Did you review the document entitled Trial Court Certification? Oh, and I'm sorry. Yes. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it electronically? Because
Yes,
it's a
ma'am.
plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so if you need anything, let probation know, or you can come back and talk to me. I'll be here till December.
Okay, ma'am.
All right, I'm gonna send you to breakout room number 3. And Greg, I sent you to 3 as well. Probation is gonna zoom in to go over conditions with you.
And Judge Greg has one more client that's here in the box.
All right, who is it?
Turk Lemus. Thank you, Judge.
Sure,
Thank you.
Lemus.
And just let you know that's the
You
reason
wanna
why I saw him is
Yes.
definitely because he threatened me when I was on the floor. Make sure like the whole story.
And Luis, I believe you can join
What's he saying?
breakout room number 3 if you know how to do that there. Good job.
Right.
And Your Honor, on this case, if you want me to
Yes.
start.
Yes.
This was from yesterday. So we're trying to work out a plea bargain. The state is going to contact the complainant, I believe, just to verify some information that's going to help us make a decision. So I just want to give her some time and appreciate her doing that.
All right, how much time do you need?
Whatever the court will allow, Judge State also gave an offer already, so.
All right, we'll do a plea deadline date. Greg, I know you teach and school ends for you when?
June 4th, Judge, but if we can get, excuse me, I'll be done before June. So anytime after June 3rd, June 4th, I can come in. But obviously if we can work something out, then I will take time to get Turk taken care of.
All right, so what I'll do is I'll set it then in May. And then if you need to move it because of class, you can just place it on a different date. Just call the coordinator.
Thank you, Judge.
All right, Norma, if you can recall this in mid-May.
The 18th.
All right, so we'll be back on the 18th. If your attorney wants you brought back sooner, he'll let us know and we'll put you on the docket.
Thank you, ma'am.
All right, thank you. All
Judge,
right,
thank you again.
All right, thank you.
Thank you, ma'am.
Who's here on Caitlyn Medell?
I am, Judge.
All righty. All right, if you'll come forward. Court is calling 2025 CR 013-984 State versus Caitlyn Medell. Could I have parties announced?
Florida, known for the state.
Charles Bunk for Miss Medell.
Are you Miss Medell? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Medell, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, state will proceed on the lesser included offense of attempted burglary of a habitation.
Any objections?
None.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on the lesser included offense of attempted burglary of a habitation. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Medell, has anyone threatened you, coerced you, placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's an $800 fine. State recommends deferred adjudication. There will be taken in consideration 2026 CR 004221 and 2026 AL 000772. And there's to be restitution to the complainant. Did you understand?
Yes, ma'am.
All right, off the record for a moment. Reynaldo Luna, I'm going to put you in the breakout room number 3. We're back on the record. Did your state in defense, do you agree that is the plea bargain agreement?
Yes, Judge.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 100 hours community service restitution, no contact with the complainant, and the cognitive thinking course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense of attempted burglary of a habitation, how do you plead? Guilty, not guilty, or no contest?
Yes.
State any evidence.
Yes, Your Honor. Seat offer States Exhibit 1 and all attachments.
Any objections?
No objection.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe she's worthy of the plea bargain. We ask you to follow it.
All right, who are these other people you were with? What is their relationship to you?
I was with the ex-boyfriend.
All right, that's a bold move to someone's on vacation. Somebody breaks into the apartment, changes the locks and just lives there.
I didn't. I was at the wrong place. So.
Well, there's no such thing really as wrong place, wrong time. That's just something that people say, right? Do you have any children?
I lost mine.
I'm sorry to hear that. How far did you go in school?
I graduated and I have some college.
All right, so what are you planning on doing with the rest of your life?
I'm going for a hygienist. I'm a registered dental assistant.
All right, well, this is what I'm gonna tell you. Anytime you have any type of criminal case, whether it's deferred or not, anything that requires you to have a license, this is gonna appear in your background. I don't say you're not gonna get your license, but you just made your life more difficult. You understand?
Yes, ma'am.
All right, it's 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. There's going to be a TAP evaluation out of custody. Follow recommendations. If TAP recommends inpatient treatment, we'll start with outpatient treatment. There's to be no contact with Julio Cesar Cadena. Toast Street.
Yes, ma'am.
And how often have you been using?
Um,
I'm sorry?
I don't use.
Well, they found a lot of things,
I understand.
Xanax and everything,
Yes, ma'am. I don't touch that. Oh, no more.
but you're with people who do.
I separated myself.
All right, there's going to be field visits one time per month until further notice. 200 hours community service restitution. I'm going to order MRT. 100 hours will be deducted for completion of MRT. The remaining hours will be deducted for every sober support meeting that is completed, 1 hour for every hour. Take in consideration 2026 CR 004221 and 2026 AL 00772. There's an $800 fine that will be probated. Probation, is there any proof of employment within 45 days of release? There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. And there's to be no residing in households with minors. Probation, is there anything else? Oh, well, I've already given her the MRT. Do you suggest cognitive thinking over the MRT? Okay, all right. Is there anything else that you need?
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Oh, and I'm sorry, there's to be no possession of firearms. All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
Yes, ma'am.
All right, good luck to you. Brenda Levenstein, who do you have?
Pablo Hall.
All right, thank you, Charles. What page is Pablo Hall on? Pablo Hall. He's not on page 2. What do you got?
Page might be 4 then. Because I gave you the.
All right. Hello, how's it going? All right, what is happening with this case? If it's a plea,
We have a plea bargain for 1244, 6 months in the Bear
I'm
County
waiting for the
Jail.
paper. I don't have the paperwork. Just give me a second.
Okay.
And then after this, I'm going to take up mental health court.
We're gonna go get it in the back page.
All right, if you'll just have a seat for me, they're going to grab your paperwork, then I'll take it up. All right, just give me a moment. They're going to grab the paperwork.
A moment. Can we talk about
All right, Pablo Hall. And counsel, are there any applications?
No.
Court is calling 2026 CR 004851. State versus Pablo Hall. Could I have parties announced for the record?
Lauren Espinoza for the state.
Brenda
the-
Levenstein for Mr. Hall.
All right, and Ms. Levenstein, you did not sign the discovery acknowledgement. Have you received all the discovery in this case?
I have.
And did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Hall, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, you need to sign that. Deputy, could you have him sign that, please?
I can come by and sign that later this morning.
Oh, you left.
Thank you. Thank you.
Okay. Can't reach.
Thank you. Mr. Hall, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hall, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the Bexar County Jail under 1244. There's an $800 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor, state offer states exhibit 1 and all attachments.
No objection.
Did you state, you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
Just that it was a very small amount of controlled substance, and I believe this is a fitting punishment for that offense.
All right, the court will follow your agreement, sentence you to 6 months in the Bexar County Jail under 1244. There's an $800 fine. Court, that time and money will run concurrently. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it
Yes.
and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's motion to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
All right, thank you.
You're welcome.
Thank you.
Can you tell me, are all the jurors here? Okay. Let me see. Has all right, yes. Mhm.
I'm Nicholas Muir. I've been here a couple of times.
Yes.
She's gonna ask the, my top two. She said she can, so we could have this sign for them.
Okay.
I didn't know she needed to have a certain, he's here.
All right, Tony Hernandez. Where's, hi. If you can go over the trial court certification with Mr. Peterson, please. My understanding is that you're doing that for Bridget Garza.
No problem.
All right, thank you. Oh, the trial court is over, it's over there.
I believe there's stuff in the wrong space. Yeah, we're in the middle.
We just finished up our case yesterday, so yeah, we'll see if we proceed.
Yeah, it's another thing. Yes, sir. Been a while.
Right.
Ms. Garza, what is happening with Mr. Peterson?
Good morning, Judge. We have an agreement to continue his probation of 45-day jail sanction. IOP, regular UAs, continue the scram and the UA hotline.
All right, so what I can tell you from reading his violations, he needs to be in inpatient treatment.
Judge, that was the original recommendation. The problem is that Mr. Peterson has severe medical issues, heart failure, and major kidney issues.
All right, so
That's
here's the thing. I mean, I understand what you're saying and I appreciate that, but, and mind you, I will keep an open mind, but it appears that you all will be pleading true to something. And what will you all be pleading true to? State?
To the number one, well, I don't know, actually, the state has not told me what they wanted him to plead.
But looking at probation's copy of the MTR, she has
True too.
the violation of condition 2 and nothing else.
All right, so here's the thing. There needs to be an inpatient treatment facility for him because he's on probation for DWI and they're asking that he plead true to violation of condition number 2, which is drinking alcohol. So if there's no inpatient treatment for him, then he needs to be revoked probably. Because I mean, he
Judge,
needs
I don't think
inpatient-
the probation department's recommendation is not for revocation. They want to continue to help Mr. Peterson. And although obviously it is completely up to the court, but the probation department is willing to work with him because they've been supervising him for a significant amount of time. And again, because of his medical issues that the probation department has proof of, that's why
there's something wrong with you're frozen sort of. But here's the thing.
to this agreement with this.
Norma, he's gonna have to be reset because the thing is, he was ordered into felony drug court. Felony drug court is an intensive program. And the fact that he's here before me and he's not here because he's graduated from felony drug court. And I don't take any of the violations to be true, but according to the motion to revoke, he's here to me, and this has been signed by Judge Glenn because they no longer want him in felony drug court. So, I mean, he has been supervised for a while, but that supervision has been through felony drug court. And could I have the file on Mr. Peterson, or you only have this? Where's the indictment on this? Just 1 second.
Can you see me now, Judge?
Yes, I can.
Okay, okay. Just to make aware, Judge, I believe the first recommendation of the probation department was inpatient treatment at ISF. But if the court would like to reset it and so that I could be in person and confer again with Mr. Peterson and with the state of Texas, I would be more than happy to do that.
Yes, because I do believe, and I don't have the motion, I don't have his indictment before me, but just one second. You know, it would be nice if they did an Odyssey where you had a search engine, and when you go into somebody's case, you can just type what you want. But I
That would
guess-
make too much sense.
yeah, that's too, as my grandmother used to say, that's too much like right.
No.
All right, so, and the reason why I say he needs inpatient treatment, you know, he's here for a DWI third, but he had, I think, approximately like 4 DWIs even before this. And I could be wrong, but I think, let me see if I can find the stipulations, not the stipulations, the admonishments. I don't even think the state wanted him to have probation to begin with. But my reasoning was obviously he has an alcohol problem and that needs to be treated because otherwise he was going to go to prison, come out and still have the same issues. And I also took into consideration that he had medical issues. So we'll reset it and we'll reset it. We can reset it the end of April or whatever day you will be available, Ms. Garza.
Okay, Judge. Thank you very much.
What date would you like?
Did you say the 27th or the 28th?
Yes, we can do one of those days.
Okay. I can do the 29th. Is the court of, or
Is
you want
that-
those 2 dates?
What date of the
That's a
week?
Wednesday.
Not on a
That's a
Wednesday.
Wednesday.
Because usually
Okay,
we're
so I can be there on the 28th, Judge.
all right, Norma, recall this for April 28th. All right, thank you.
Okay, thank you, Judge. May I be excused?
Yes.
Okay.
Are we still missing a juror? All right, is Laquan Jordan here?
That's the ones we brought this after.
The inmate was not brought over because he's impossible. He's on page 1.
Okay. All right, send that to Judge Nahara, Judge Halsted. All right, who's next? Adam Cruz? Yes. Mr. McLean, on what date is good?
Okay. Yeah, it'll work. Thank you. Not on Tuesday, yes. 20th of May? I should work. 1 second.
And then they'll take care of the bond issue in Magistrates Court.
Why not? What time was right?
All right, on this case, where are we on discovery? I know you were appointed recently.
Judge, I've actually gotten the discovery.
Mhm.
I've gone through it all, downloaded all the videos. We've gone through it. I'm talking with Mr. Prater this morning, trying to see if there's some way we can get a resolution on this thing.
You want to recall, I can recall it back on May 21st. However, we'll put it on May 21st, but if your attorney wants you brought over sooner, all he has to do is let us know, okay?
And Judge, I've also, we had a motion to reduce the bond on his case as well. This was a bond that was set by the MAG. I've been trying to get it over to Nahara's court, and I just can't get in there to get them to.
You get it over there today. Norma, when he goes to Magistrates Court for Montez, get the, who set this bond though?
MAG.
Oh.
So you can.
No, I can, and so can another magistrate.
True,
Yes.
however you want to, do it, Judge.
Take it to, see if you can come with agreement with the state and then take it to Judge Nahara,
Okay.
and they'll handle that with Montez as well.
I talked with Lauren about it yesterday,
Mhm.
and she didn't have any, she obviously didn't want the PR bond, but she was like, I'm gonna let the judge do with the amount, whatever they want to do.
Mhm.
And so.
He has a conviction for AGI, so he's not allowed to have a PR bond, but I don't oppose whatever reduction the court sees fit if
All right.
that's.
So if you all, just take it to Judge Nahara.
He's here today because.
Oh, somebody, who's here?
26 is over in his court.
All right, who's here for Judge Nahara? Yeah, oh, they say he's here. Nahara is here and Halsted should be here.
Okay.
Just one
Just gotta
second.
find him.
We're gonna make sure, we're gonna make something happen today. And then, like I said, we'll bring you back no later than the 21st.
Mhm.
But if your attorney wants you brought over sooner, we can definitely have you brought over sooner. Okay.
You know, that's saying that. So. Okay, I got one reversed.
You can put it for disposition. All right.
Thank you, Judge.
All right, thank you, thank you. Good seeing you.
Weekend.
All right, you too.
Yeah, taking it over.
Yes,
Have 2 dismissals here.
okay.
What I would like to see is.
Sure. There you go.
Thank you kindly.
You're welcome. Hi.
That's what he wants.
All right, and then you have a travel
Yes, Judge, and the state said they would remain silent. It's my understanding that Mr. Martinez is currently on misdemeanor probation and it's a trip for a medical.
Okay, just give me one moment.
Sure, thank you.
Yes. Thank you.
Sure.
That motion to reduce bond, do I need to check that or not, Ron?
Oh, yes,
Thank you.
you're welcome.
Watch out that.
Okay, just give me one moment. Let me put this in real quick and then I'll take that from you.
There. Good thing. Okay.
All right, thanks. Oh, sure. Probation, here's this. And then,
that's not-
oh, yeah, it's probation, yeah.
I'm gonna bring that.
And if you could let Marissa make a copy of that, please.
Sure, thanks.
Okay, sure.
Thank you.
You're welcome.
Thank you.
Norma, to swear in those, the people who graduated or passed the bar, you can put it at any time. Yes, just. Ready? All right. Court is going to call 2025 CR 004-128 State versus Simon Alexander Garza. Can I have parties announced?
Oh, sorry, Lauren asked member to speak. For City of Edward Audrey Martinez for Mr. Garcia.
And are you Mr. Garza?
Yes.
All right. Last night, there were more cases that were sent to the court by the state. I'm sorry, by the state and the defense. The court has had a chance to review those cases. Is there any further argument?
Just briefly, Judge, is that, and let me make sure I tell you what cases. Williams v. State that we sent to both the state and yourself, Your Honor, that states that we cannot confuse criminally negligent mens rea with reckless mens rea. And I believe in the state's argument, they specifically argued that Simon should have known, and that is not.
Just 1 second. They're talking over to the side. Let me let them finish because I'm trying to focus. All right, yes.
That is not the correct mens rea in this case. And if the state believes that they have put on evidence of criminally negligent as a mens rea, that is not sufficient or equal to proving a mens rea of recklessness. And at the, and also in Williams, the state, it says at the heart of reckless conduct is a conscious disregard of the risk created by the actor's conduct, mere lack of foresight, stupidity, irresponsibility, thoughtlessness, ordinary carelessness, however serious the consequences may happen to be, do not suffice to constitute either culpable negligence or criminal recklessness. I do not believe that the state has put on any evidence of recklessness.
Any further argument?
Judge, I believe that my closing argument was mischaracterized by the defense. I was not saying that he should have known. I was saying that he was consciously aware of his surroundings. We have evidence that of his statements immediately after the crash to Officer Salazar, that he knew he had the red lights, but he went through it anyway. He nodded when the officer asked him the question. This is a positive affirmation of that. And Judge, the standard for recklessness is conscious disregard of a foreseeable risk. Mr. Garza's statements to Officer Salazar show that he was conscious and he was aware of what he was doing, which was driving through that intersection when he had a red light. Further, Judge, looking at the state of last night, sending 3 cases to yourself, to my second chair and the defense, all of them go into almost the same fact pattern that occurred here, that there was speeding and that there was a car that went through a red light. All of which said that the evidence was more than sufficient for a fact finder to find guilt beyond a reasonable doubt. This is from multiple jurisdictions. I believe one is from Dallas, another one is from Austin, another one is from Houston.
But in this case that we have before us today, wasn't there testimony by the state's witness that maybe all of the white lights were red, and then that maybe the defendant had a green light, maybe the complainant had a red light, or no one, has there been any testimony where someone definitively said that the defendant had a red light? And when I say definitively said, I mean that there's no one else who has testified. Maybe it could have been green.
Judge, I believe what you're referring to is defense exhibit number 4, which was that screenshot of all the lights being red. However, when we went back, we showed the full video, not just the cherry-picked screenshot that showed that the lights were all red for an instant before they turned green. We further expounded on that by showing that this is what happens at an intersection with traffic signals. They all are red at a certain point before they cycle again. And if you take that amount of time, the jury can infer from that video, from that rebutting of, and I think Selenus's video is in evidence. The images
But
are there.
I'm not just talking about the video. I'm talking about witness testimony.
There was testimony, I believe it was when. I believe it was Officer Salazar or Officer Armstrong who was speaking about this, and we showed the jury the complete video from Officer Salazar showing that the lights cycle like that properly. Further, Judge, there was testimony, not just the defendant's statements, but also from Adelina, who was in the car, and she said the light was green. He had the red. We have abundant testimony. Yes, and further, we have abundant testimony and evidence that we have submitted to the jury where they can properly infer, and that is the standard from all of the case law, whether the jury can reasonably infer from the evidence something to fulfill one of the elements of the offense. We have shown all that further.
Excuse me. Could you line the jurors up and could you just let him sit in the back?
Yes, and Judge, even though there is a statement later on by the defendant that he was unsure whether his light was green or whether his light was red, that is self-serving hearsay. That is his own testimony after the fact, where he's had more enough time to think about and formulate a different line of thoughts. And Judge, I think that if anything, his statements immediately after the accident, before he becomes aware that he may be the target of an investigation, is much more telling as to his state of mind than as to 40 minutes afterwards when he's had time to dwell on this.
Okay, but you're saying his statement is self-serving, but you all offered it into evidence.
We did, Judge, to show that, because that is indicative of guilt. Like the one statement and then a now inconsistent statement. It shows an indication of guilt, of awareness of his surroundings, and that it's an indication of guilt, Judge.
Okay, any final argument?
Judge, just the fact that the state is saying the cases that they provided are consistent with our facts, I disagree. We've got speed in excess of 40 miles an hour over in one, driving into a different oncoming lane of traffic. I mean, the facts in all of these cases are different. They are not consistent with our case. They're drastically different. And the state is making assumptions as far as our client's mens rea, and that has not been proven. There has been testimony, like you are referring to, Judge. Officer Salazar testified it was possible that the lights were red. He also testified that he was assuming that Simon's light was red because of the other light. There has been no absolute direct evidence or circumstantial evidence, just an assumption that the light was red, that the light was red.
All right, thank you. All right, could you bring the jury in? Defense's motion will be granted. Bring the jury in.
All right, for the jury.
All right, everyone, please be seated. Ladies and gentlemen, I'm going to read to you the charge of the court. You do not have to memorize it. You will have it back with you when you begin your deliberations. Charge of the court, members of the jury, the defendant Simon Alexander Garza stands charged in count 1 of the indictment with the offense of manslaughter alleged to have been committed on or about October 13, 2023 in Bexar County, Texas. To this offense, the defendant has pled not guilty. 1, our law provides that a person commits the offense of manslaughter if the person recklessly causes the death of an individual. 2, individual means a human being who is alive. 3, a person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, the court, having determined that the evidence is insufficient to support the jury's finding of guilt beyond a reasonable doubt, has granted the defendant's motion for a directed verdict and herein instructs you to find the defendant not guilty of the offense of manslaughter as charged in count 1 of indictment. A verdict form is provided for you. After argument, any and all communications relative to this case must be written and prepared by the presiding juror and submitted to the court through the deputy. Do you understand? All right. Could I have their, the list of jurors, please? Thank you. Are we ready?
Ready, Judge?
Yes.
All rise for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, have you reached a verdict in this case? And is it unanimous? All right, if you'll hand the verdict to the deputy, please. Thank you. The verdict form reads, we, the jury, find the defendant Simon Alexander Garza not guilty of the offense of manslaughter as charged in count 1 of the indictment. Does anyone wish to have the jury polled?
State does not make that request.
No, Judge.
All right, thank you. All right, ladies and gentlemen, the deputy will take you back to the jury room and I'll come in and speak with you, and the parties may want to speak to you as well. Everyone, please rise for the jurors.
Jury, Paul.